Morning,
Yes, sir.
sir. I am Sourav Mohapatra. I passed my 10th from Saraswati Shiv Mandir, Bargad, and 12th from Vikas Junior College, Bargad. I done my 5-year BA LLB course from MS Law College and passed out in the year 2019, and LLM from that institution in criminal law specialization in the year 2021.
What is deterrent theory of punishment? What is deterrent theory of punishment?
In deterrent theory of punishment, and the punishment is imposed on the person so that other person of the society prevent deter the and prevent themselves from committing similar type of offense.
Why a person is punished for committing an offense?
A person is punished for committing an offense to prevent him from commit further offense, and it set example for the society that other persons shall not commit similar type of offense.
Is there any other purpose for punishment? It's the only purpose. Okay. What is gift?
Gift is a voluntary transfer of property without any consideration from one person to another person, and it is accepted by the transferee.
What is vested interest?
So when a property is transferred upon happening of a certain event, then the transfer property is called vested interest.
Then what is contingent interest?
When the interest in a property is transferred upon happening or non-happening of an uncertain future event.
What properties cannot be transferred?
Section 6 of the Transfer Property Act let down certain property which cannot be transferred. Such as easementary right, mere right to sue, pension gratuity, the property, the transfer of which is violation of natural law.
When a
Mere
police
right of
officer can
maintenance.
arrest without warrant? When a police officer can arrest without warrant?
Police officer can arrest a person without a warrant when the offense is committed in his presence, or when a reasonable complaint or any information or suspicion exists that that person has committed any offense punishable with more than 7 years.
If the police officer is required to follow any provisions before arrest,
Yes, the section 41 laid down certain condition which the police officer has to comply before making any arrest.
what is doctrine of double jeopardy?
A person cannot be punished twice for a same cause of action, same offense. It is laid down in Article 20, Clause 2.
When a person can be tried for the, even if first acquittal is there for the second time.
Sir, could you repeat the question? It is not audible.
Can a person who has been acquitted of an offense, he can be tried for that offense for the second time?
No, but he cannot be tried for the similar offense for the second time.
What is a warrant case?
No, when a person can be punished with imprisonment for life or death sentence or any term of imprisonment more than 7 years, more than 2 years, then it is a warrant case.
Can police arrest a person in a non-cognizable offense?
Police arrest a person in a non-cognizable offense when the person commit any non-cognizable offense in presence of police and he doesn't give his whereabout. Then the police can arrest a person in non-cognizable offense.
What is affray?
Pardon, sir, I cannot recall that exact provision.
What is mischief? What is mischief in IPC?
When a person com- commit any wrongful loss to another person without gaining something in return, then it can be a mischief.
What is abduction?
I cannot recall the exact program. Pardon, sir.
How issues are framed? On what basis issues are framed by the civil court?
After the plan and it statement are filed on the basis of material produced before it, the court can frame issue under order 40.
When a plaint is to be returned by the court,
Under rule 10 of order 7, the plan can be returned when it is not filed in proper code.
what is pleading? What is pleading?
The contention of the plaintiff is called pleading.
What is a suit of civil nature?
When any right, title, interest, or claim in a property, then it is called a suit of civil nature.
What is declaratory suit?
When a person deny or interested to deny the right title of a person, then the person against whom it is denied, he can file a declaratory suit under section 34 of the Specific Relief Act.
What is estoppel?
When a person said anything and to another person and that other person believing upon his statement act upon it, then the person who state the statement cannot deny from his previous statement.
What is dying declaration?
When a person give a statement about the cause of his death or any circumstances which lead to death, then after his death, his statement shall be considered a dying declaration.
What is confession?
Any statement made by the accused person that he has committed the offense or any fact which constitute the offense, then the statement is called confession.
What is admission?
Any statement, oral, documentary, or electronic forms, which suggest an inference as to fact in issue and relevant fact made in any circumstances laid down in section 18 to 21 of the Evidence Act, is called admission.
When admission of a third party becomes relevant,
So, when any reference is made to the statement of the third party, then the admission made by third party is relevant.
what is hearsay evidence?
The generally the evidence of a person who has seen or or his own opinion as relevant, but when it refer to opinion of any other person or anything seen by other person, it is called a hearsay evidence.
What is primary evidence?
The document itself produced is called primary evidence.
What is the difference between private document and public document?
Sorry, sir, I cannot recall that word.
Okay. When a divorce by mutual consent will be allowed.
But after commencement, after marriage, when 6 months has been passed, after that the party can file a mutual divorce, and there is a certain waiting period. After passing of that, the court can pass a decree for mutual divorce.
What is hiba in Mohammedan law? If Mohammedan law
Hiba
was a
means
subject,
it
if
is gift.
Mohammedan law was in your optional subject,
Yes, sir.
okay.
It was my optional, sir.
What is hiba?
Hiba means gift. Any transfer made without consideration, and it is accepted by the transferee. It's called hiba in Muslim law.
If a registered document is required for hiba under the Mohammedan law,
The registration is not compulsory under Mohammedan law.
what is khulla divorce?
Sir, I don't know.
Anyhow, I will give my feedback after the second interview is done. Thank you.
Good morning, Sourav.
Good morning, sir.
Good morning. Please tell me, what do you understand by human right and fundamental right? What is the difference between the two?
Fundamental right means the right which are given under Part 3 of the Constitution, and when the right is breached, then the aggrieved person can directly move to the Supreme Court under Article 32. But and there was no such provision to directly approach to Supreme Court for the violation of human right.
Okay. What is your specialization in LLM?
Criminal law.
Criminal law. Okay. Can you tell me what does section 300 of CRPC says?
Section 300 of CRPC tells that when a person is convicted or acquitted by the competent court, then he cannot be tried for the same offense again.
Okay. What is the difference between theft and extortion?
In the main difference is there is a presence of force in extortion, but it is not there in theft.
Okay. What is the difference between indemnity and guarantee?
In indemnity, there are two parties only, but in guarantee there are three parties, and and
And
my optional paper was not contact law, so but I'm sorry, I cannot remember the exact position.
okay, will you say this when a case under contract comes before your court also?
No, I cannot say it.
A civil judge is expected to know all subjects. Doesn't matter whether you are having any optional or not. Okay, no issues. Can you tell me what is the procedure to appoint a high court judge?
The High Court Collegium recommend the government the name of the judges, and on recommendation of the collegium system, President approve the name of the High Court judge.
Who is in guardian ad litem?
I don't know, sir.
Okay. Who is a garnissee? What is a garnissee?
Judgment debtors is called garnissee, and then it means the degree holder can tell the garnissee to uh, pay to pay the amount directly to the degree holder instead of the judgment debtor.
Okay. They said international law is the vanishing point of jurisprudence. Why is it called so?
Pardon, sir, I don't.
Okay. What is an obiter dicta?
Obiter dicta means the judgment passed by court is set precedent for the future reference.
Okay. What do you understand by uh, the set off in CRPC?
Sir, I don't know.
Set off. Have you heard set off?
I heard it in CPC, but I don't know in CRPC.
Okay. Okay. Tell me, what do you understand by set off in CPC?
When a case is filed by the plaintiff against the defendant and the defendant had some claim of money against the plaintiff, then in that suit, the defendant can file a setup against the plaintiff for the claim.
What is facta provanda and what is facta proventia?
The in a case the party has to plead only the fact, and this is called factum first one, and the provincia is he is not allowed to prove the evidence, not allowed to plead the evidence in his pleading.
Okay. A magistrate sees someone committing a cognizable offense outside his jurisdiction. Can he arrest him?
Yes, he can arrest that person under section 44 of the RPC.
But 44 says that within his jurisdiction he can arrest. I'm asking outside his jurisdiction.
He can arrest a person as a normal human being,
As a private person, you mean? Okay.
as a private person.
Yes. And private person arrest is done under which section?
Section 43.
43, yes. Yes. Can you tell me when does trial commences? When does trial commences?
After completion of investigation and inquiry, trial and framing of charge, trial commence.
At the stage of framing of charge or after framing of charge?
After framing of charge, trial. No. After inquiry, trial commence.
Okay. If I go to the police for registering the FIR and the police does not register, what remedies do I have?
The aggrieved person can approach the superintendent of police directly by in person or by in any written grievance in post for registration of FIR, and the police officer, SP can direct any subordinate officer to register the FIR, or he can file a complaint, or if it is if the above two procedure not followed, then he can approach to the uh, High Court directly. But there was cases.
Yes. Yes.
But there is cases where it is written that the police officer is bound to register FIR. Lolita Kumari case.
Can I approach the High Court if police does not register the FIR?
A person cannot directly move to High Court for if the police officer doesn't register FIR. He have to follow that procedure laid down in 154.
Okay. Can you tell me when an instrument may be rectified?
When the instrument doesn't reflect the true intention of the party, then the instrument can be ratified under 26, section 26 of specificity.
There is a conflict between fundamental right of life and right to privacy. What will prevail?
Sir, I don't know.
Okay. Okay. Can you tell me what do you understand by adopting a privity of contract? Privity of contract.
Privity of contract means generally the party entering into contract can enforce it, but there are certain person who can enforce the contract without being a party to it.
Okay. Okay. Tell me a recent Supreme Court judgment which is making a huge impact in the society.
So the judgment of related to LGBTQ and marriage related to their marriage related issue case, Supriya versus Union of India.
What was held in that case?
It was held that the LGBT Q community had done right of adoption in marriage, and they cannot entitle the right which are available to married couple. And there is a guideline for relating to adoption also.
What does the recent Supreme Court judgment on Article 370 say?
Uh, the recent Supreme Court judgment Article 370 said that the abrogation of Article 370 is constitutionally valid because it was made for a temporary purpose, it not a permanent.
Okay. 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 Thank you, Sourav. Let's proceed to your feedback now.
Thank you, sir.
Okay, Sourav, you have completed your LLM in probably criminology, or you are still doing your LLM.
I have
Have you
completed
completed?
my LLM in
So
2021.
deterrent, deterrent theory of punishment. I put a question. Your answer was submitted correct. So deterrent theory of punishment is that for a heavy punishment is given, that is called deterrent theory of punishment, so that society will deter to commit such a crime. The best example of deterrent theory of punishment is death sentence. The highest punishment is given. Object of punishment is not preventing, not only preventing. When punishment is awarded, punishment is given, if the person against the victim's personal revenge is satisfied. That is the first requirement. In every crime, a person is victimized. When he is punished, the revenge of that victim is satisfied. First. Then also it is that this also preventive theory also preventing that person, deterrent theory and other punishment is there. After some years, if a person suffers punishment, after he is released from jail, society forgets the crime and allow him to be a good citizen of the society. That is the punishment. That is the reason of punishment. First reason of punishment, suppose X committed a rape. If he is not punished, the relative of that victim will search for an opportunity to take revenge on that man. Once a punishment is given, that is the first personal revenge of the victim is satisfied. That is the best answer, probably. Gift is a voluntary transfer of existing property, existing movable or immovable property made by a person without consideration, called donor, to the person called donee, and must be accepted by the donee during the lifetime of the donor and still capable of giving. That is existing movable or immovable property. These words voluntarily without consideration by a person called donor to the donee, and gift must be accepted by the donee during lifetime of the donor. That is gift. Vested interest you fail to answer. When an interest is created in favor of a person without specifying the time when it will take effect, or it will take effect forthwith, or on the happening of an event which must happen, then that interest is called vested interest. Contingent interest means when an interest is created in favor of person with condition that will take place on the happening or non-happening of a particular event, then that is called contingent interest. Property cannot be transferred also. Section 6 provides certain property is made apart from the movable, immovable property that cannot be transferred. Is made with this immovable property can be transferred. Mere re-entry that cannot be transferred. Space succession, mere right to sue that cannot be transferred. This public office that cannot be transferred. These are things you aware. When a police arrest without warrant, in case of a cognizable offense, police can arrest without warrant, but following the provisions of the CRPC as laid down from section 41 to 60. All these provisions, when a less than 7 years punishment, why arrest is required, all such provisions are there. Police will follow the directions as provided in the CRPC from section 41 to 60 before arrest. That is there. Double jeopardy. Okay. Doctrine of double jeopardy means if a person has been convicted or acquitted, he cannot be tried for the same offense once again. That is doctrine of double jeopardy. Section 300. There can be a second trial after acquittal with the that is with the consent of the government. If the magistrate or the court was not competent to try that. That is, even acquittal is there, we should go through section 300, clause 4, etc. Even after acquittal, for the same act, a separate charge would have been framed, but the court who tried it, the court who tried it was not competent. Say for an example, magistrate second class tried a theft case and acquitted. If on the same facts, he cannot be, because magistrate second class has no power to try an offense on section 394. For that robbery, he can be tried once again. That is, when the acquittal remains in force, also such a second trial is permitted. Non-cognizable offense in presence of the police, a cognizable and non-bailable offense is permitted. Then police, a private person, no, sorry, you are also correct regarding non-cognizable offense if a person does not give his address, disclose his address. Where appropriate, not address. After two or more person fight in a public place, disturbing public peace. That is after. Two or more person fight in a public place, disturbing public peace. That is after. Mischief. Whoever with an intention or knowledge causes any damage or destruction to the property of the public or of any person is called mischief. That is mischief. Abduction. Whoever by force compels a person or by deceitful means induces a person to go from one place to another, that is called abduction. Framing of issues. Issues are framed on taking the plaint and written statement or the pleadings of the parties and on hearing the parties. That is issues. But there, then pleading is not a plaint. But pleading is either plaint or written statement. Both are called pleading. Plaint and written statements are called pleadings. Suit of civil nature when the right to property or office is in dispute. That is a suit of civil nature. Then estoppel, if a person by his act, declaration or omission has made another person to believe a particular thing to be true, and on that belief the other person has acted upon, then in a suit the person who did that act, who was given that declaration, cannot deny the truth of the same. That is called estoppel. It is a rule of evidence. In declaration, any statement given by a person regarding the cause of his death or any of the transaction of the circumstances leading to his death, that is the declaration, that is admissible when the cause of death of that person is in dispute. Admission, third person, admission is You are correct also. We suggest an inference to the fact in issue or relevant facts. Relevant facts. Then admission of a third party becomes whose position is to be proved as against a party to the suit. That is, admission of a person whose position is to be proved as against a party to the suit. That is, though he is not a party to the suit, but he is a third party and his admission is relevant. Here's evidence is that evidence a person who has no direct knowledge on the matter. Hearing something, he says something in the court. Primary evidence means the document itself produced for inspection of the court is called primary evidence. Original document. What is private document and public document difference? Public document is defined in section 74 of the Evidence Act. Document or any act or forming the record of the act of any official bodies, tribunal, legislative, executive, and judiciary, all official matters. That is this public document. All other documents are private documents. That is in subsequent. All other, we play not of a public officer, official bodies, tribunal, legislative, executive, judiciary, or where if there is a provision also keeping public record of the private document, that is a public document. But all other documents are private document that is mentioned in section 75 of the Evidence Act. Then divorce by mutual consent, when the husband and wife may file a petition for divorce on the ground that they are living separately for 1 year and more and they are unable to live together. Second condition. Third, they have mutually agreed to dissolve their marriage by a decree of divorce. Then they can file a petition before the court for divorce by mutual consent. And if the court is satisfied regarding the genuineness of the petition, if that petition is not collusive, then the court, not earlier than 6 months, not later than 8 months, can pass a decree for divorce by mutual consent. You are doing well, but some concept you are forgetting. When you are not in a position to answer that, you may say, excuse me, I do not remember. Excuse me, I cannot say so. That is, it appears that you are nervous. Why you are nervous? Don't worry, everything. Be with confidence, you remain there. Don't be nervous. Because as an usual manner, as a daily routine life, you appear that interview. Please have faith in God. You do your duty. That whatever result will come, that is the wish of God. Thank you.
Thank you, sir.
Yes, Sourav. Yes, as sir pointed out that I've told you previously also. I can see that you are not nervous, but because you don't smile at all, that's why it seems that you are nervous. Okay, so maintaining a happy pace in the interview is very important in the sense that it makes you look not nervous. Okay, it makes you look that you are not nervous and you are content or you are interested in the interview. Sometimes it looks that you are not interested in the interview. Okay, so that is because of the lack of expression. So be expressive. So when someone sir asks, nodding head, saying yes, okay, or all right, okay, sir. So mentioning all this, what it makes you human. It makes you feel like that you are not a robot. Okay. If you feel like a robot, then that will be a problem. And that is what is making you feel like making us feel like you are nervous when you are actually not nervous. Because I can see that you are doing well, you know the concepts well. So what is the problem? Why will you be nervous? There is no reason to be nervous. Okay, appear appear to try to be expressive. Try not to have a robotic face. Be expressive, and that will make the interviewer think that you are interested in the interview, and he will be happy to ask you questions and then select you. Okay, because I always say the initial impression that you make in the interview, that is what will carry throughout. Initial impression that will be carried throughout the interview, and once they find a reason, one reason you give to satisfy to select you, then they'll find 100 reasons why they should select you. But if you give them one reason not to select you, then they will find 100 more reasons not to select you. Okay, so introduction, it's a marketing. Basically, you are selling yourself. What are you doing? You are selling yourself. You are a salesman here to sell your product. You are a good product and they should buy it. That is what you are here to preach. If a salesman comes and says, "Sir, this is a product and I want you to buy it," why will you be interested? If someone says, "Sir, this is a very good product," and that's so I'm not saying you be friendly with the panelists, but you look interested. That will make sure that the interview goes better. Okay. Now the next the questions that you could not answer, some of them you could answer, a lot of them. Some questions you could not answer. Guardian ad litem is a person when a minor is a defendant. So what happens if a minor is a defendant? Then in that case, for that minor, a guardian ad litem is appointed by the court who will fight the case on behalf of that minor. Okay. Indemnity and guarantee. In indemnity, there are two parties: one who promises to indemnify, and there is a person who has given that. But in guarantee there are three parties. One another person is there called the guarantor, who is a third party, who also promises that in case the person who has taken the loan or anything, if he doesn't pay, then in that case this at least will be paid by him. Okay. Next is international law is the vanishing point of jurisprudence. Yes, international law is the vanishing point of jurisprudence. That was said by observed by Holland, and he said that because international law does not apply to the state specific, it is not state specific. That it cannot be applied to all states. It is a writ large. So that is why they call international law as the vanishing point of jurisprudence, because it differed from ordinary law and it is not supported by the authority of the state. Normally, the law should be supported by the authority of the state. Because it is not supported, that's why it is called the international law is the vanishing point of jurisprudence. Okay, what is an obiter dicta? Obiter dicta is something which which does not have any binding authority. That is said by the court, but it does not have any binding authority. Okay, and privity of contract you mentioned, theft and extortion you also mentioned. Set off under CRPC, that is in 428. Whatever punishment you have already gone through, that punishment will be set off. That means suppose you are an under trial prisoner, you have suffered certain imprisonment. Then in that case, that imprisonment period will be set off from your conviction sentence period. Okay, suppose conviction is given and 3 years is given. Now you have stayed inside jail for suppose 1 year, then you will have to suffer more 2 years. Okay, that is set off. What else? Yes, privity of contract you could say. Magistrate may arrest. Yes, later on you could get to that point. Yes, magistrate may arrest as a private person. If he is doing it outside his jurisdiction, he may arrest as a private person. Okay, that is it. And you please try that. You please revise, but you please try to look interested. Okay, that is all about that. Okay, like you're right now you are responding. When I'm saying something, you respond, but you'll be like if you don't, because I'm telling you the most of the communication happens through non-verbal communication. If I say directly, Sourav, what is your name? Sourav, what is your name? Then you're getting it. That I am interested to know your name. So non-verbal communication is a must here. So that's why you should focus on the non-verbal part also along with the verbal part. Because I can see you have concept. Why? What is there to be afraid of? Okay.
Okay.
Okay. Thank you, Sourav. When is your interview?
Last date 22.
22. Okay, we will schedule it around 19 or 20. I'll let you know when is it. Okay. The third one. Be ready by that and prepare your core subjects and optionals accordingly. And next time when I see the interview, you must be looking interested. That's I hope. Okay. Okay. Thank you. Thank you, Saurabh. You may join now.
Thank you, sir.
Thank you.